Joining me now is NBC News senior legal correspondent and Weekend Today co-host Laura Jarrett, former Obama White House policy director Dr. Kavita Patel, and Boston Globe columnist, attorney as well, Kimberly Eikens-Dorr. She's also co-host of the Sisters-in-Law podcast. Welcome to all of you. Laura, think about, just imagining the emotional, the medical, the logistical, the financial challenges of having to travel 600 miles or more from some states, surrounded by similarly restrictive states. The court says that the doctor did not prove that Cox's condition was life-threatening. Her lawyer says that it proves that exemptions, these, like saving the life of the mother or whatever, don't work.
Yeah, I think, Andrea, what this really does, as you so powerfully articulated, is it shows the high threshold, the high bar that women have to meet in these situations. And a lot of people talk about medical exemptions as though it's a safety valve. But if the safety valve doesn't cover somebody who has been to the emergency room 4 times in the last month alone, somebody who was having cramping, leaking fluid, going through all of these various symptoms, some symptoms that her doctors said, not us, but her doctors said were serious. The medical exemption doesn't cover that situation. It makes you wonder what it does cover. And so I think that this case just sort of shows you how narrow the exemptions really are in reality.
And Dr. Patel, let's talk about the medical situation here. I know women who have had troubled pregnancies, preeclampsia, were really, their lives were at stake. But doctors have said you can't tell when is that crossing point. When does it cross over into, yes, the life of the mother is in danger?
Yeah, Andrea, could you imagine if now the pressure put on doctors, not just in Texas, but in states all around the country, if the pressure put on doctors is to say, yes, Ms. Cox, this absolutely is going to be fatal. You will die if you don't have ... When we know that is one, it's a statement that is irresponsible to make, because in many situations, there is no kind of one and only outcome. And by the way, medical exceptions were not meant to say that this would be fatal. And I think it's insulting. I don't try to pretend to be a lawyer or a Supreme Court justice or like any of my panelists, or Andrea, I couldn't do your job. I will say, I don't think people should try to do my job after decades of training, when what we are trained in is not just the science, but we are also trained in trying to give patients as much of a spectrum of the possibility. And in this clear situation, it wasn't just the mother's life, it was her reproductive future, which she clearly wanted, and the fact that she would have a baby that had a fatal condition. 97% of these babies do not live to year 1. And if they do live past, they are so severely developmentally disabled and in chronic need of support. Those should all be decisions that are kept between a medical team. To have a Supreme Court and justices play this out, to doubt these medical kind of opinions, honestly, Andrea, it's backfiring and only putting more pressure on the medical team to make statements that they are not prepared to make.
So, Kim, you are the lawyer here, who is, as well as Laura Jarrett, in our legal correspondent. But, for the two of you to just explain to us, Kim, you first, what does the Supreme Court here in Texas do now? Where does this case go? How long will it take? You've got Arizona, New Mexico, Wyoming also hearing cases that are similar about abortion access.
Yes, well, some of these cases will undoubtedly find their way back to the highest court in the land, the U.S. Supreme Court. It's unclear whether this Texas case will, since Ms. Cox has left the state to get her case. That case could be deemed moot. But the Texas Supreme Court, she had left before this decision came down, so they didn't have to issue it. What the court was clearly doing, the state's highest court was clearly doing here, was issuing a warning to other people, saying, look, this is somebody who had the financial, mental, and emotional wherewithal to lodge this challenge at the same time they are dealing with this reproductive crisis. And if anybody else who does not have that wherewithal even thinks about trying it, don't. I mean, that's what this comes down to. You do have cases in Kentucky and elsewhere. I think it will go back up to the Supreme Court, which will have to deal with the aftermath of its Dobbs decision and how it's playing out in real time to real pregnant people across the country.
And Laura, a pregnant woman in Kentucky now was suing to overturn her state's ban but her attorney today announced that her embryo no longer had cardiac activity. Talk to me about that case.
Yeah, and that, I think, is the sad reality for her situation, as in so many others who have experienced miscarriages at weeks, which is not unusual, but it sort of shows you the bizarre situation we're in now. Tracking which of these fetuses have cardiac activity. It's sort of, that's the legal landscape we find ourselves in with these cases where people are currently pregnant. That's an unusual circumstance, Andrea, but again, sort of the natural output of where we are post-Roe, with everything being done state by state, sort of this bizarre patchwork of the current landscape. And I think these are going to continue. As we talked to Kate Cox's team last night, they told us they are fielding calls from other pregnant women looking to challenge these state bans.